We have moved the tables around. You are now sitting in a chair that does not rock or swivel. You will be directly facing the bench, and you will be more in my line of sight.
Let's go. That's
I
right.
want to caution you.
Yes. That's why she's sitting there? Is that what he said? I keep an eye on. Oh, you're going to behave. You're going to sit in your goddamn corner and shut up. Make sure you guys check out my channel sponsor, Data Seal service that I use to protect myself from the crazies online. Something as simple as your phone number, your name, your email address. People can pull up your addresses, your family's addresses, locations, all kinds of stuff. So protect your information with Data Seal. Your information is being sold by data brokers all the time. It's easy for anybody to look up your information using people search websites. They can find your home address, date of birth, email address, phone number. Dataseal.io is the data removal and monitoring service I trust to remove my information from the internet. Click the link below and use the code 5OFFALL to save 5% off your Data Seal subscription.
Ms. Stauch, you have the right and obligation to be present for your trial. Being present permits you to see the evidence the prosecution is presenting against you. It permits you to communicate with your lawyers while that is going on and assist them in your defense. You also have the right for the jury not to see you in restraints that are commonly associated with being held in custody or confinement. That way, the jury does not see you as a prisoner or someone who is in custody and is not prejudiced against you because of that. These rights, however, are not without limitation. While you have the right to be present for your trial, you also have the responsibility to behave with the respect and decorum required for this formal proceeding. You also have the responsibility to behave in such a fashion as to make the use of additional restraints unnecessary. Sometimes, during trial, a defendant chooses to act out. The likelihood that that will happen, in my experience, seems to increase the longer the trial takes and the more serious the charges are. And I know that right now we're in week 4, or we finished 4 weeks. We're starting week 5. You aren't the first defendant to act out. Probably not going to be the last. I cannot imagine the pressure a defendant feels during any trial. It's not uncommon for a defendant to disagree with certain testimony or dislike a witness or a victim. Nevertheless, you cannot act disrespectfully in words or actions. First of all, it never helps you out. You've already heard one juror submitted a question regarding his observation of your conduct. They don't miss anything. It also makes your attorney's job much harder. They need to focus on the evidence presented and how to counter that rather than your conduct in the courtroom. I am also aware of the practical realities that exist in this case. I could hold you in contempt for your conduct in the courtroom. That would mean that I could impose a sentence of up to 6 months of jail for each incident of conduct which I find to be contemptuous.
Ooh.
However, in a case where a defendant is facing decades or even life in prison, if convicted, a 6-month contempt sentence does not seem to be much of a deterrent. But that does not leave me without a remedy. We have moved the tables around. You are now sitting in a chair that does not rock or swivel. You will be directly facing the bench, and you will be more in my line of sight.
Let's go! That's right!
I want to caution you again.
Fuck that, yes! That's why she's sitting there? Is that what he said? I keep an eye on your ass. Oh, shit, you're going to behave? You're going to sit in your goddamn corner and shut up!
That does not rock or swivel. The tables, that does not leave me without a remedy. We have moved the tables around. You are now sitting in a chair that does not rock or swivel. You will be directly facing the bench, and you will be more in my line of sight. I want to caution you against certain actions, such as waving your hands around, trying to stretch your fingers out, and leaving one of them more prominent than the other. Those acts would be, in my opinion, disrespectful to the proceeding. It's disrespectful to the court and the legal process. I also view it as a form of witness intimidation and an attempt to influence presentation of evidence in this case. If that conduct occurs again, it would be a violation of the decorum I expect in this case. Everybody that's sitting in the gallery sees signs that have already warned them of the same kind of conduct. You can't do it either. I may then impose other remedies. I could simply have a bolt installed on the underside of the table and have your hands cuffed to that bolt. You wouldn't be able to use your hands. The jury wouldn't be able to see the handcuffs.
What? Yo, this is what I missed when I was getting coffee? What?
We have a bolt in. I may then impose. You can't do it either. I may then impose other remedies. I could simply have a bolt installed on the underside of the table and have your hands cuffed to that bolt. You wouldn't be able to use your hands. The jury wouldn't be able to see the handcuffs.
Wow.
It would be uncomfortable. I could have you removed from the courtroom and the trial would proceed without you. You would not be returned to the jail. Instead, you would be held in a holding cell in this building. You know how uncomfortable they are.
That's where I came in.
You would then be transported back to the courtroom at every break to see if you had changed your mind and agreed to behave in a respectful manner a courtroom requires. And you would be brought over for the next day of trial, and we would start all over again. So, with that, is the prosecution prepared to proceed?
Yeah, we are, but there are a couple.
Amazing. Holy